Welcome to Sakshi TV's special immigration show with attorney Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week: on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi Reddy needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is Employment-Based Green Cards Part 4, I-485. We will continue the knowledge session along with the news and updates on latest immigration followed by Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask tips. Hello, Ms. Prashanthi.
Hi, Torani. How are you?
Very well, thank you. I hope you're doing well as well.
Yes, I am.
So,
thanks for asking.
Ms. Reddy, before we jump into the topic, are there any immigration updates that you'd like to give us and your viewers?
No, let's just jump into the topic because immigration news has been slow recently. The only update I have is not really an update because I've been saying it in the last few shows, is that Biden has changed he has removed the travel ban and he has changed the criteria for who can come in into the country. So Indian nationals are no longer banned from coming to the US as long as they have the Covaxin or Covishield vaccination and they're fully vaccinated. So that's, a piece of good news that I don't mind resharing.
Right. Ms. Reddy, so we'll get started with the topic right away. So we're discussing I-485 today. So I'll start with a very basic question. What is an I-485 and how does one file it?
So in order to get a green card, USCIS always likes to complicate things. So in order to get a green card, there are usually 3 steps, and we have, for those who are following our show, we have completed the first 2 steps. The first step was the PERM or the labor cert filing. The second step is the I-140 filing or the filing of the immigrant petition. And the third step for those who are in the US is filing for adjustment of status. The adjustment of status application is called a 485. I'm saying application because when an individual applies for themselves, it's called an application, and when a company applies for you, such as a H1, it's called a petition. So the 485 application, because it's been filed by the individual, is the application for adjustment of status. It's the final step in the green card, and it's possible to file a 485 only when your visa number is current. And we've been talking about visa numbers and visa bulletins and priority dates in our previous shows. But for those who are just tuning in, the green card numbers are, a limited number of amount of numbers are released every year, and only that many green cards can be issued. And each country is given an equal number of green card, about 7% of the worldwide green cards are given to each country. And you can see what your priority date is or when you can file the 485. So you can file the 485 based on when your priority date becomes current. And you can see if your priority date is current or not by going into the visa bulletin, which is available on travel.state.gov visa bulletin. And then looking at your categories, since we're talking about employment-based, it'll be EB1, EB2, or EB3 categories. And we touched upon what those categories are in our last show. So when the visa bulletin says that your number has reached, that means if it has your date or it has moved beyond your date, then you can file for the 485. As I said, the 485 is the last step in the green card. And The benefits of a 485 is that you get employment authorization. So if you do not want to be on your non-immigrant work visa, you do not have to. You do not have to continue to be on a H1. But there are certain advantages of doing that, and we can discuss that later on in the show. But you do get an EAD, you get an advance parole to travel, so you don't need to go out of the country and get a H1B visa and run the risk of not being able to come back into the US if the Department of State or the consulate doesn't give you the visa. So those are the benefits. You get EAD, you get advance parole, which acts like a visa. And the biggest benefit is that you're allowed to move employers without, moving of employees is a very easy step. You just have to fill out a form 485J. It's not like transferring employers in a H1 where you have to fill out the I-129, you have to meet certain criteria, the case has to get approved, only then you can move. In a 485J, you simply inform the USCIS through the form 485J that you are working in a similar position as the position that was approved for the perm, and the I-140 should be approved, 6 months should have elapsed since the date of filing the 485, and you're allowed to transfer. So it gives you that flexibility. And on an EAD, you can work 2 jobs. So you can work with your petitioning employer, and you can also do a job on the side. Or you can, work for yourself. You can start your own business. So it gives a tremendous amount of flexibility to be on a 485 application.
Right. So, Ms. Reddy, you were saying that there are certain differences between somebody filing a petition for you and you self-applying. So, are there any major differences or any major privileges or benefits by, for somebody who applies on their own or gets the petition through an employer?
So, all 485 applications are applications that are filed by the beneficiary, that is the applicant. There is no employer involved in the 485 stage. The employer is involved in the labor stage and in the I-140 stage. And Torni, by now you must have learned everything about a green card, so you're ready to file a green card on your own because you've listened diligently to our entire series on green cards. So as you know, in the labor you always need an employer. In the I-140 you need an employer, but the good thing, well, in the I-140 we discussed that you can be self-petitioning also if you are exceptional ability, national interest waiver. Then there are some instances, EB1, those are instances where you are extraordinary ability in the arts and sciences. So in those instances, even in an I-140, you can self-petition. A 485 is, all that is over now. A 485 is where you're adjusting status, so there's no employer involved really except for the employer filling out the 485J. And if you are self-petitioning, then there's no 485J because there's no employer. In general, self-petitioning is obviously better because you're not bound by a job or bound by the employment offered by that employer. But in most cases, 99% of the time, it is employment through an employer. An I-140 through an employer is approved, and then the 485 is filed by the applicant. So the employer is not involved here except for signing off on the 485J, which is an offer of employment. They're basically saying that, yes, we continue to offer employment. But it's signed, the I-485 is signed by the applicant, the attorney's fee is paid by the applicant, they have complete control over their process. They can call USCIS to find out what their status is. They can make changes to the application. So everything, they are interviewed. It's not the employer that's interviewed. So this is completely an applicant-driven process, which is, very unlike the first 2 stages.
Right. Ms. Reddy, just to clear, I just wanted to say that, of course, you've given us a lot of information throughout the whole series of employment-based category green cards. But of course, pardon me for asking these questions. Let's just say I'm trying to be a viewer who's trying to, ask generally asked FAQs. So moving on to our next question, could you please explain to us what documents are required to file an I-485?
Yeah, absolutely. And I'm glad you asked. So in order to file a 485, you have to first, because you're adjusting status in the US, you have to show that you are in status. especially for employment-based cases. There are some exceptions to that if you're filing a family-based case. And if it's an immediate relative, then there's no requirement to show you're in status, even if you're out of status of a parent, child, immediate relative, spouse can apply for you. And you don't have to be in status. But for our employment-based purposes, where we're filing adjustment of status applications, we always have to show that you're in status. And the 485, so in order to show that you're in status, you have to submit a document showing that, which is usually an I-94 or approval, a I-797 notice. Say you're on a H-1B, then the H-1B approval. And you also have to show, in case of a H-1, that not only do you have an approval, that you're actually maintaining status. So in that instance, you would have to show pay stubs or an offer letter from your employer saying you're working, presently working. Because unless you're working on a H-1, even if you have an approval, you're not in status. So you'd have to submit pay stubs. Of course, you'd have to submit a copy of your passport, all the relevant pages of biographic pages of your passport. You'd have to submit documents to show your identity. Your birth certificate you'll have to submit. And if you don't have a birth certificate, you can submit alternative secondary evidence. And for Indian nationals, that secondary evidence is usually a school leaving certificate, notarized affidavits, birth affidavits from people who were present at the time of your birth or know of your birth, saying that they were present, and this is how they know you, and this is how they know that you were born on so and so day. So those are the secondary evidences: school leaving certificates, which is called a TC certificate, birth affidavits, letter from a priest or religious organization, and also letter from the hospital where you were born. So this is accepted secondary evidence for India, for Indian nationals. Every country is different. And for Indian nationals, if you do not have a birth certificate, you also have to submit a non-availability certificate from the registrars of birth and deaths, which is usually the municipal office in your town. So these are the documents that you need revolving around birth. You also have to submit secondary evidence if your birth was registered late. So if you're not registered at the time of your birth or close to the time of your birth, say you registered 10 years later, or you just registered before filing the green card, then you'll have to submit secondary evidence as well, even though there is a birth certificate. Sometimes our birth certificates don't have names, quite often, because a child is not named at the time of the birth, generally in India. In that instance, you'll submit the birth certificate, and then you also submit affidavits from your parents saying that, this is my wife, we're married, I have 2 children, one of my child is so-and-so, and as per naming protocols, the birth certificate doesn't have a name, but this child is so-and-so. So that can be done as well. So in addition to a birth certificate, the passport, proof of status. If you're married, then a marriage certificate. If you're a child and filing for a 485, then your birth certificate will show your parents' names, and the parent is obviously the principal sponsor, and you're the dependent. So that is proof of relationship. If you're a spouse, a dependent spouse, filing for a 485 based on employment base, then the marriage certificate shows proof of relationship. And that's the basis for filing. So these are some of the documents that are required. Also, tax returns might be required. In employment-based cases, generally, the affidavit of support, which is an affidavit to show that you're able to support your dependents after they get the green card, is not required in employment-based cases. So we don't usually submit an affidavit of support or tax returns. But in family-based cases, yes, you have to submit tax returns and an affidavit of support, employment letters to show your salary, etc. So I think then the other documents that you could submit is if you have, say, an arrest, or if you have, a misdemeanor charge, or if you were not charged but you were arrested, then documentation showing that, and documentation, if you were actually convicted, then documentation showing the court order. And they usually ask for certified copies or originals of the court order. So they want to make sure that you're still eligible for a green card even though you were convicted of a criminal offense. Sometimes you're not, and sometimes you are. If it's just a misdemeanor and if it's a one-off offense, then you have something called the petty offense exception, where if it's just one offense and if that offense happens to be a misdemeanor, then they will forgive it. If it's an assault, that might be a felony, and if it's a felony, then you might not qualify. You might have to submit additional documents to show, despite the fact that you have a felony, why you qualify for a green card. So you have to show a waiver, and you have to submit a separate waiver application. So these are, I think we covered most of the documents. In addition to that, of course, you'd have to submit the forms, the Form 485, the I-130 for advance parole, the I-765 for work authorization. You have to submit 6 photographs if you're doing all the applications, two photographs for each application, and you have to submit a check properly written, with no typos, for $12.25. So if you're an adult, if you're over 14. So, and then all this has to go to the right service center. So this is, I think, Torani, I've covered all the documents that are required, most of the documents at least, that are required for a 485.
Right, Ms. Reddy. So before we go to the next question, this is a note for all our viewers. You can call us on the numbers displayed on the screen for immigration related questions and to ask tips from Prashanthi Reddy herself. So Ms. Reddy, moving on to the next question. What is the processing time for an I-485?
So the processing time for a 485, that really depends on when it is being processed, because processing times always change. They're never the same. If the date is current, so we were talking about visa numbers, priority dates, right? So a 485 can be filed when your priority date is, the final action date is current. There are 2 dates in a visa bulletin. One is dates for filing and one is final action date. When it's actually available, that's the final action date. And once you file it, then if it doesn't retrogress, because every month the date changes, if it doesn't retrogress, then it should get approved in 12 to 18 months. If there is an interview, it could take longer. If there are issues, of course, if there's an RFE, it can, it might take longer, but usually that's the processing time. But if you are filing based on the other category, which is dates for filing. Dates for filing is basically where USCIS is allowing you to file in advance of your dates becoming available, because they anticipate that until the processing time is complete, then by then your date will become available. So 12 to 18 months, they're anticipating that the date will be available, so they want to take your application in advance and process it. So in that instance, of course, then the processing time can take much, much longer depending on when your final action date becomes current. And we've seen wait periods of 5, 7 years, 8 years, 9 years in that category. So it's hard to say what the processing time is in that situation. But if it is current, based on final action dates, should take about 12 to 18 months.
Right. Understood, Ms. Reddy. So moving on to the next question, what kind of RFEs are we looking at right now? So the RFEs that we're seeing are mostly those that were filed, the big filing month was October of 2020. That's when the visa numbers became available. The dates for filing were available. The dates jumped, especially for EB3. So we're looking at RFEs that are coming from those cases right now. And the RFEs that are coming right now are those basically requesting documents. I mean, a lot of people didn't submit their medicals, so we're getting RFEs for medicals. We often get RFEs for birth certificates because there's some defect in the birth certificate, or there is secondary evidence was not submitted, or the birth certificate was not submitted. Most often than not, even after everything is submitted, you still get an RFE because they don't notice that, we sent in a birth certificate and they ask for it again. And then there could be RFEs asking for, say, the I-94, sometimes when the latest I-94 is not included. So it's basically RFEs asking for missing documents is what we're seeing right now. There's no other major issue with 485s other than just the missing documents. Right. Right. Ms. Reddy, so could you please also explain to us and our viewers what AC job portability means?
Right, AC21.
AC21, right.
AC21 job portability. So as I was when I first started the discussion on 485s, whatever 20 minutes ago.
Ms. Reddy, please forgive me
Yes.
for disturbing, but we have a caller. Mr. Shekhar
Sure,
from
sure.
California. Thank you for calling. Mr. Shekhar, you may ask Ms. Reddy your question directly.
Yeah, sure. Thank you for the opportunity. Hello, Ms. Reddy. I think my question is, I received my EAD and advanced payroll approval Monday this week. So my question is, my H-1B visa is already expired in 2015, and I've been here in US since then. But my H-1B approval also is still till October 22. I already paid fees for the visa in India, and they are not opening any appointments there. So now my question is, if I travel now to India once I get my EAD card, and if I come back, I'll try to see if I can get my H-1B stamping in December, but for some reason consulate doesn't open the appointments. If I re-enter with the EAD and advanced payroll card, will I lose my H-1B status, and is there any way to come with EAD card and still be on H-1B status? Is there any way?
Yeah, absolutely. So this is, a question that has been asked, is the favorite question people have, because quite frankly, not everyone knows the answer to it, and sometimes people are confused about what the answer is. But time and time again, USCIS has confirmed that you can travel out of the country with an advance parole and still come back and renew your H-1B status. So you can maintain your H-1B status while traveling on an advance parole. So that is absolutely possible. The only thing is that you cannot work on an EAD and then maintain your H-1. So as long as you're not working on your EAD, but you're only traveling on advance parole, it's fine. You can maintain your status. You can come back and extend your H-1. So in case you don't get a visa at the consulate, or you're not able to get an appointment, then you make sure you have your advance parole in hand. So congratulations, I'm glad that your AP got approved. So you can travel on an AP. Yeah.
Thank you. Thank you so much for that.
You're welcome.
Thank you for calling, Shekhar. So, Ms. Reddy, let's get back to AC21 job portability. You were saying.
I was saying that we were discussing this earlier when we talked about the advantage of being on a 485. And so the biggest advantage is this portability, the ability to change employers without too much of an effort or a big application to the USCIS or an approval from the USCIS. So that's what AC21 job portability is. The criteria for AC21 job portability is that the job should be same or similar. It just says same or similar. It doesn't say has to be exactly the same. You have to just send out an application, which is a 485J, which is quite a simple application. And 6 months should have elapsed from the date of filing the 485, and your I-140 should have been approved. So if these criteria are met, then you are allowed to change jobs. Now there's a lot of nuances with the AC21. Since it's not clear as to exactly what same and similar means, there's a lot of debate on which jobs, does it have to be exactly the same? Can the tools be different if it's an IT position? Can the salary be higher or lower? How much similar should it be, or how different can it be? So my take on this is basically, as long as it's within the IT space. For example, if you're in an IT position, your job was approved under PERM as a program analyst, and you are filing your AC21 application because you're transferring to another employer and they're giving you the job of a software engineer, I would say it's still similar or same. It doesn't have to be the same SOC code. Some people seem to think that in order for AC21 to be approved, the SOC code has to be exactly the same. It doesn't have to be. So at the same time, say you have a labor approved as a program analyst and you're filing as a financial analyst. I mean, it's very clear that it's not similar or same. So just use your common sense. I think anything within the IT space, pretty much USCIS is accepting it as similar or same, as long as it's, a related job. So that's another nuance for the AC21. But otherwise, yeah, so 485J has to be filed, I-140 has to be approved, 485 has to have been filed at least 6 months ago, and the job has to be same or similar.
Right. That was great, Ms. Reddy. So, after a person gets their green card, right? So, is it possible for them to work for 2 companies simultaneously and not the original company?
So after you get the green card, my suggestion is that they work for the original company for at least 6 months. So when I say original company, I mean the company that last did the AC21. So the reason why they should work for at least 6 months after getting the green card for that company is so that when they're filing their citizenship application, there are no questions raised as to whether the offer of employment was a bona fide employment or not. If they didn't work, because the whole idea of the employment is that once you get the green card, we're going to hire you. It's a permanent position we're hiring you for. So that's the whole premise for the 485 and the 485J, offer of employment. So I recommend that they work for the petitioning company for at least 6 months. In addition to that, if they want to work for another company, absolutely, they can work for 2 companies, 3 companies, as long as they work for the employer that petitioned their 485.
Right. With that, Ms. Reddy, we come towards the end of the show. And before we end the show, is there any golden immigration message that you'd like to give our viewers?
You always put me at a fix when you ask that question, because I have to think now, what is the golden message?
I don't mean to, but I'm sure our viewers can use some advice from you.
Of course, my dear. I'm just pulling your leg. But so the 485, since we're talking about 485s, I would say, though a 485 form seems simple enough, because it seems like there's biographic information, there's your name, there's your address, there's a lot of nuances in it. And there are a lot of questions, yes or no questions, which seem simple enough, but oftentimes you need legal advice to know how to answer them. Because you might, if you say no for yes or yes for no, then the entire application is affected. Then you'll get an RFE, then there'll be questions asked about it. And it's so easy to miss out columns, not fill out columns, because they're several pages long. And even we as attorneys make mistakes sometimes. So my only golden advice is don't do it yourself. What is that acronym for it? DIY?
Yeah, DIY.
Don't do it yourself. DIY. It's not a DIY application. Don't do it yourself. There are a lot of nuances to filing a 485 and a lot of cross-checks that have to be done between the I-140 application, the 485 application, making sure your employment is the same, the information given is the same, and there are no discrepancies. So, that's my only golden rule, is that, take a good legal help when you're filing a 485.
Right. Ms. Reddy, that was quirky yet brilliant advice, and on that note we end the show. But before you go away from the team of Sakshi, we'd like to wish you and our entire viewers a very happy and a safe Diwali. It was a privilege hosting you.
Thank you so much. Happy Diwali to everyone.
Thank you, Ms. Reddy. You're watching Sakshi TV Live with me, Tordi Makana. Thank you.